Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about a lawsuit that's been filed against a baby food maker. I'll have more on that in just a moment. It is often the case that the federal government or a state government like the state of California will issue a report that will prompt litigation. And in this case, that's exactly what happened. The federal government did some studies and they found out that, among other things, certain baby food brands had unsafe levels of chemicals in them. This is a paragraph from the petition filed in federal court in New York, and here's what it says. Parents and other caregivers, including plaintiffs, reasonably believe that the baby food they purchase for their babies will be healthy, nutritious, and non-toxic, and that is what Hain wanted them to think. Alarmingly, parents and plaintiffs were wrong. A recent report by the U.S. House of Representatives Subcommittee on Economic and Consumer Policy, Committee on Oversight and Reform, reveals that certain brands of commercial baby food, including defendants Hain's Earth's Best organic baby food, the Tainted baby foods, are tainted with significant and dangerous levels of toxic heavy metals, including arsenic, lead, and then they go on to name cadmium and I think selenium and several others. So the bottom line is that there are these baby foods and they have these high levels of potentially toxic chemicals in them. Now, there are, of course, a couple of problems with the analysis here is that just because the samples that the government analyzed were tainted doesn't mean that all of them were, and that is going to be an issue of proof when it comes time for the lawsuits. But in addition to that, the plaintiffs in that case said this: no reasonable consumer purchasing baby foods or seeing defendants' representations in advertising would expect the baby foods to contain dangerous levels of heavy metals or other undesirable toxins or contaminants. Furthermore, reasonable consumers, like plaintiffs, would consider the inclusion of dangerous levels of heavy metals or other undesirable toxins or contaminants a material fact when considering what baby food to purchase. Defendant intended for consumers to rely on its representations, and reasonable consumers did, in fact, so rely. However, the business's practices of the defendant were deceptive, they were omissive, they were misleading, unfair, false, because, among other things, they had these chemical levels in them. So in the complaint that's filed in federal court, the plaintiffs give this background for the case. They say on February 4, 2021, the House Subcommittee issued its congressional report detailing its findings that heavy metals, including arsenic, cadmium, lead, and mercury, heavy metals, were present in dangerously significant levels in numerous commercial baby food products. The Food and Drug Administration and the World Health Organization have declared heavy metals dangerous to human health, particularly to babies and children who are most vulnerable to their neurotoxic effects. Even low levels of exposure can cause serious and often irreversible damage to brain development. See Congressional Report at 2. In fact, children's exposure to toxic heavy metals, among other things, permanently decreases in IQ, diminished future economic productivity, and increased risk of other diseases. So it's pretty clear that the allegations here are pretty serious against these manufacturers. But you're probably wondering why we're talking about reliance and all that kind of stuff. Well, that's because this was filed as a consumer class action. Now, consumer class actions are different from product liability lawsuits. And here is how they are different. First of all, they require a false representation made to consumers. Now, usually that's in advertising or in labeling or some other place where a consumer can be reasonably assured to have read it. Then the consumers acted on those representations, and those representations were proved false and their reliance on those representations was reasonable. In other words, the claims were not just completely outlandish. The consumer then sustained economic damages as a result of buying a tainted product, and the consumer should get back the money that they paid for tainted goods. Now, what's important here is there is no claim for personal injury in this lawsuit. And that's because personal injury claims require proof of damages. Damages in personal injury lawsuits tend to be individualized determinations. In other words, you have to show what John Smith suffered as a result of the defective valve or the defective car part. And as a result, that it cannot involve the showing of common proof. Now, if you have a scheme like this, a consumer fraud scheme, where, for example, you have a common scheme to provide advertising that says that your product is safe and it turns out not to be safe, well, that is something that can be shown by class-wide proof, and as a result, it works pretty well in class litigation. But personal injury claims tend to be disfavored in class action litigation. That's why these lawyers and these clients took this path. Now, I would be remiss if I did not point out that there are sometimes criticisms of class action lawsuits, and particularly consumer class action lawsuits that are based on rescission and repayment of funds that have been made, restitution. As a result of that, I think that for the most part, state legislatures have sort of cracked down on how easy it is to bring one of these claims. But the fact is that if somebody is injured to the extent where they paid, I don't know how expensive baby food is, but I'm sure that if you have a child that requires baby food, it costs you a fair amount of money to put that child into baby food. And if you've spent that money and you got a tainted product, there's absolutely no reason you shouldn't get it back. The problem tends to come in the way that damages are calculated, and the fact is that almost none of these actually wind up going to trial. If the plaintiffs can get the class certified, it becomes a bet the company case, meaning if they can establish that there is reasonable grounds to impose punitive damages, that someone recklessly disregarded the safety and health of the consumer, there is a good chance that punitive damages could be awarded by a jury. For that reason, in almost all of these cases, if you get the class certified, you will almost always get a settlement. And of course, the settlement will usually pay the attorney's fees. And when these attorneys are working for $600, $700, $800 an hour, those attorney's fees mount up pretty quickly and can sometimes eclipse the amount of money that the class as a whole gets. Now, judges are called upon in that situation to reform the deal if it's unfair to the consumer and unfair to the client. And as a result, a lot of times in the appellate process especially, those attorney's fees get kind of clipped a little bit. But it is a useful way to sort of aggregate cases that where there is a common bond that sort of links all these cases together, and where, if you spent $500 in a year on baby food, the likelihood that you would want to pay a lawyer $500 an hour and go after a company for $500 is pretty unrealistic, frankly. Let's suppose that you bought baby food over the course of a year and you paid $500 for that. And you had receipts and that sort of thing. Maybe you put it on your credit card where you could show that indeed you spent this money and you spent it for these particular things. Well, in a consumer class action, you could band together with all the other people who had the same problem, and you wouldn't have to pay an attorney between $200 and $500 an hour to bring that case. You could foist the problem off on the manufacturer if you were successful. And in most cases, attorneys who bring class actions tend to bring them under the no fee if we don't win sort of thing, a contingency agreement. For that reason, it's fairly safe to get involved in a class action lawsuit. That's why these cases are allowed in the first place, because when you have a small injury, but millions of people have that injury, there has to be a way to recover that for the people who were injured, even if it's not a large amount. Now, there have been a lot of criticisms in the last 20 years about what are called coupon settlements. For example, when Hertz was sued for the Las Vegas airport, I guess they called it a facility reclamation fee or something, they were sued, and what Hertz decided they wanted to settle the case with was a coupon that was good for a free rental over some period of time. Well, the problem with that, of course, is that it forces you to deal with the person that defrauded you in the first place, or allegedly defrauded you in the first place. And so that class action settlement was not approved because it was essentially a coupon settlement. And coupon settlements are disfavored because there's no real remedy for the victim of the class-wide fraud. That is sort of the 411, the inside baseball on class actions and why this case was brought in that manner. In a day or so, I'm going to talk about a similar case brought against this particular company, and that being for autism and how the hurdles are so great in that case. So stay tuned for that in a couple of days. If you have any questions, please leave them in the comments down below. Like, share, subscribe, tell everybody you know that this is a good place to come for legal information. Thank you for watching and have a marvelous day. I'll catch you on here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.